Very interesting topic called marriage. As I told you that many years ago, when I asked my family law teachers what is important, we were having our end of the year exam. Then at that time we did not have even semester system. So we used to have just one exam. And of course, we had sessional tests. So this is how he said, well, marriage is important for me, you, and divorce is important for me. Gift is important for you, and inheritance is important for me, and will is important for me. And he went on to list all the topics of my course, and therefore we had to study everything. My first statement, since I'm not a great moralist, nor I believe in moral policing, increasingly, if you look at world at large, the institution of marriage is under stress. Yesterday in the newspaper, there were picture of Indian parents whose children decided same-sex marriage, both were gays, and the parents are giving their blessings. And therefore, in number of countries today, same-sex is not only has been decriminalized, that is one aspect, that in the privacy of their beds, you do something. Chalo. But even legalizing same-sex marriages. If you look at the divorce rate, then इधर नहीं देखना है. The divorce rate as such has gone up in almost all countries in the world. In United States, every fourth or fifth marriage does result in divorce. So the sanctity of marriage, the importance of marriage, the institution of marriage is under huge distress. And therefore, when we look at the whole question of divorce, whole question of dissolution of marriage, we need to keep these new developments in mind. My analysis of our Supreme Court's reaction to the questions of divorce and to the kind of debates we had in Lok Sabha is that we are living in some different world. We still continue to attach too much of importance to marriage, and therefore any breakup is something which we can't digest straight away. But that is not the reality of 21st century. That was the reality of earlier times. Islam made a major change in law of marriage. And brought several reforms. First of all, prior to Islam, as we have discussed before, but not in that much of details, the female had no choice in the marriage. So it was not a union of two equals. It was a relationship of subordination. Even today, under the Hindu Marriage Act, when you have Kanyadan, it is not reflecting like a union of two equals, because the father is giving the daughter in marriage as a daan. And daan is always given of a thing, not of a human being. We have discussed yesterday itself and day before in criminal law as to the offense of kidnapping, that the words used in the English statute was taking a child out of possession of father or the guardian. So the children were in possession of parents. Until 1955, when we got the Hindu Marriage Act, a Hindu was entitled to have unlimited number of wives. So unlimited, unrestrained polygamy was lawful until 1955 for Hindus. But for Muslims in 6th century itself, you had only, in rare situation, which we will discuss, just 4. And therefore Islam was ahead of other religious traditions, because from an unlimited number, restricting it to 4 itself was a major reform. So we will look at the whole question of polygamy in Islam. Our thesis is, this is not a right, this is an exception which can be practiced only in exceptional situations, and no one can say that every Muslim has a right to have 4 wives. We'll see what is the empirical evidence and other things in other communities. We'll come to that. Then making marriage as a contract was a revolution. And therefore Islam is to be given this credit, that rather than considering marriage as a sacrament as we have under Hindu law, of course with some reforms you cannot say it is entirely sacrament, but Islam treated it as a civil contract. Even today under the Indian Contract Act, contracts can be oral or not. There can be oral contracts. And therefore, what are you reading, man? Huh? No need to see at the moment. When I refer to something, then you can see. Lost. What was I saying? There can be oral contracts. Therefore, if marriage is a contract, it is not necessary that it should be reduced in writing. Yet all Muslim marriages in India are reduced into writing. There is a certificate, a nikah nama, and in that nikah nama, names of the spouses, whose son and daughter they are, what is the amount of meher or dawah which the husband has to pay, who are the witnesses, the qazi, the agents, all these sign. Agent is called wakil. He is not the lawyer in our sense, but he is called wakil. And in a typical Muslim marriage, I don't know how many of you have witnessed any Muslim marriage. Have you seen any Muslim marriage? You have seen it? So it goes like this. that there is a congregation, men, women. If you are very liberal, then there will not be any segregation. They will all be sitting together. If there is some parda, so there will be an enclosure where women are there and men are there, and then there will be a stage. One stage where husband with friends generally sitting, another stage where wife is sitting. And then we see that some papers are being written. And then suddenly you will see that 3 men will stand up and they go in the women's enclosure. So generally the tradition is that somebody who is close to the wife, would be wife, invariably the maternal uncle or a chacha or a poopa or a khalu, your auntie's husband, along with 2 other people. These 3 will go, and this man who is related, with whom that girl is familiar and does not hesitate, he will ask that I am your agent, because this is settled before that function within the family, that act will act as agent within the family, it is decided. But it is formally done that he will ask that I am your agent, do you approve that I am your agent? And do you give me permission that I go and tell the Qazi and the others that you want to marry X with these witnesses, with this amount of money? And she will say yes, and then she will sign those papers. Their signatures. But the nikah is not yet over. It is just the permission thing. And with that permission, these 3 will come, and then the Qazi will ask this agent, oh, did you go there? Did you ask her? Did she say yes? And he will say yes. Then he will ask the 2 witnesses, did you hear? They have to testify, give an evidence. And just like contracts can be oral, Indian Evidence Act permits oral evidence. So evidence can be oral. And then they will ask, oh, did you hear? She said yes. Oh, yes. Then this man will stand up, will go to mic and read some verses which are not necessary, by the way. No verses, no qazi is otherwise required. Only witnesses are required. And then he will say, do you accept so and so with this meher I give? And the husband will say yes, which now the other side where men are sitting, they will hear the husband saying yes. There has been some jurisprudence developed. If you think of women in rural areas who are very shy, who will not say openly, yes, I accept that girl. So some jurists have said, if she keeps quiet, just nods, that is also enough. Acceptance by conduct. If she slowly weeps, there has been a tradition when women used to, no more, because many a time now they themselves select their spouses, and rightly so. So they will not cry anymore today. The joke of day before was that Valentine Day and also Mahashivratri, that if you are unmarried, it is happy Valentine Day for you. But if you are married like me, then it is happy Mahashivratri. This was the joke of day before. If she weeps loudly, That is a protest. That means there is no consent. Even though she had not said no. And I have seen at least 2 instances where the Qazi had to say, no, this marriage cannot be performed because she is saying no. So by her conduct it is to be seen, and it is a public, in a public gaze it is happening, whether there is a consent. Making her consent necessary for marriage contract was a revolution. Was something very important. Gave her equality to marriage. Now there has been some debate as to the nature of Muslim marriage. Of course, it is a contract if you look at its legal nature. But if you look at it theologically, it's a religious duty also. It is a sacred covenant. The Prophet is on record to have said that marriage is half of the Iman. It is half of the religion. Therefore, Islam does not believe in same-sex marriages. Being a religion, it is tilted in favor of morality. And therefore, if you can afford, and this is important, you should marry only when you can afford. If you have means to support her and means to sustain your family. And if you cannot afford, then you are advised to fast. Maybe due to fasting, your sexual urges may get suppressed. I don't know. But this is what it is. If you don't have means, you can't afford, then don't marry but fast. Vrat rakh lo. It is also on record, Prophet has said that the best amongst you is one who is best towards his family. And therefore you need to take care. Then it is also on record that in marrying, look for virtues. Don't get carried away by the beauty and this and that. But if you want to see it, even Prophet at that time, 6th century, is saying it's better if you see your would-be spouse before marriage. And for that time it was a revolution. When you had a parda system, this, that. So marriage as such legitimizes society. I told you that the contrarian view is that marriage is legalized prostitution. You will recall in PK also that statement made by Amir Khan about condoms and this and that, and then why people with all the band and baja, they go and they say that they are having the first night. So there are people who are having a contrary view, but as far as Islamic law is concerned, there cannot be a marriage without consent. And since marriage is a contract, you can lay down whatever conditions you want to lay down. It's a special contract, a sacred contract, and therefore it must be complied with. So the leading case on the character of Muslim marriage is called Abdul Qadir versus Salima, which is a judgment of Allahabad High Court, authored by a leading first generation Indian judge, Justice Mahmood, who was son of Sir Syed Ahmad Khan, who is the founder of Aligarh Muslim University. Justice Mahmood was a great judge. Justice Subba Rao, former Chief Justice of India, has written somewhere, in past, in India did not have a better judge than Justice Mahmood. At present, there is no better judge than Justice Mahmood, and India may not have a better judge than Justice Mahmood. He resigned, and at that time appointment, he was the first generation judge, one of the first who were appointed to the High Court by the British government, and wrote more than 100 pages resignation, making all kind of charges against the British Chief Justice, including this, that in the morning walk when he meets me, he expects me to say good morning rather than he saying good morning to me. So Abdul Qadir versus Salima, he says, marriage among Mohammedans is not a sacrament, but purely a civil contract. And though solemnized generally with recitation of certain verses from the Quran, yet the Mohammedan law does not positively prescribe any service peculiar to the occasion. There is no need to recite any verse. There is no need for qazi. What you need is a public declaration that X and Y have come together and they want to start their life together. And the object of any marriage, like any other system, is to have a normal family life and have legalization of children. So what are the essentials of Muslim marriage? You need to have an offer called ijab. You need to have an acceptance, qubul. And you need to have sufficient witnesses. Under Hanafi law, 2 witnesses. Under Shia law, witnesses are not necessary. As you make a distinction in contract between invitation to treat and offer, करते हैं ना difference? आपको फ्लैट में पढ़ा दिया होगा कार्लिल वर्सेस कारबोली की स्मोक बॉल कंपनी, लालमन शुक्ला वर्सेस गौरीधर, हार्वे वर्सेस फाइसी, all these. That there is an offer and there is an offer to offer. So an offer to offer is not the offer. You have to make a real concrete offer, and it is to be accepted in the same meeting. And therefore you have to say that I have married myself to you. And she will also say that I have married myself to you. Of course, under Islamic law, they are not united blood to blood, flesh to flesh, bone to bone. Under English law, marriage meant that her personality merges with the personality of the husband. Islam does not believe in merging of the personality. In fact, wife is not supposed to take the name of the husband. So her surname does not change. She will retain the name of her father. If she wants, under modern circumstances, to adopt the name of the husband, she can. Have you seen any husband adopting the name of the father? No, wife? Why? Why should she adopt your name? So this must be expressed in one meeting, the proposal made at one meeting, acceptance at another meeting will not constitute a valid marriage. Then as to the capacity of marriage, the whole debate goes on that the Prophet married a child, Aisha. The modern researchers show that she was not below 18. Even though you will know until 19th century, child marriages were a norm. Even today, child marriages happen in lakhs in India. When I was taught this provision, like you, I contested, अरे सर कहाँ होती हैं child marriages? वो जमाना चला गया सर. My teacher, who is no more, Amika, you don't know. You need to read Rajasthan, Tamil Nadu. Tamil Nadu has a lot of child marriages. It's notorious in child marriage. Believe me. Same evening, I went to buy something in a market near my hostel. And I saw one cycle rickshaw. And on that cycle rickshaw, I saw 4 brides and 2 bridegrooms. One bridegroom was in the lap of somebody. And therefore I was curious, so I was also on a cycle, I followed them. These were the people who are into the ironsmiths, into the making of tawas and the chimtas and other things. They call themselves descendants of Maharana Pratap, and they are the nomads which can be seen in different outskirts of the city. Because it is a new story after 2014 that we now say that no, it was Maharana Pratap who won and Akbar lost. Of course, as you know, both the armies were led by Rajputs themselves. Akbar was not there in the battle of Haldi Ghati. And I always feel, somebody who won, why somebody will escape and will run away and will live like this? If you won, you have to, with all the mukut and taj, have a victory procession. The mere fact that Rana Pratap escaped from there means that he lost the battle. So child marriages, you can Google and find out the numbers you have, even though we have an old law, almost 100 years law against child marriages. But child marriages do happen. The third major revolution which Islam made and brought it as to their law of marriage is called option at puberty. Doctrine of Khairul Bulugh. If a child has been given marriage, on attaining marriage, that child can nullify the marriage. The child has that right on attainment of marriage to say no. Attainment of maturity. Attainment of maturity. If you look at law of majority globally, you will see that the age of maturity under different systems at different points of time has been different. So sometimes we say it is 15, at another times we said it 12. Privy Council which was the highest court of adjudication during the British regime, in a case of a Shia, said that the age of majority for girl is attained at 9. Today, with better food intake, at least amongst the elite, and with more exposure to TV and all kinds of ads, children attain maturity earlier. So much so that we amended our Juvenile Justice Act in spite of much opposition by me. And it was done by somebody who is very close to me and a good friend of mine, Maneka Gandhi. The Convention on Rights of Children says you will not have a criminal liability for any child below 18. But we brought in a new classification and we said even children below 18, if they have attained sufficient maturity, will be punished. Of course, Indian Penal Code itself makes that a distinction. Before 7, there is no liability. But after 7, if you have attained sufficient maturity, you are to be held liable, may be held liable. But this new law is absolutely regressive. The point I am trying to draw home, for the purposes of personal law and the capacity of marriage, if you look at global practice and dig past 1821 are recent developments. But giving this option to the minors, that if they have been married during their minority on attainment of majority, they can nullify the marriage. It was a forward-looking, rational, and absolutely reasonable step. Dissolution of Muslim Marriage Act 1939 fixes 15 years at the age of puberty. But this can be changed. It can be made 18 if we want. That brings me to the question of number, disabilities. In the whole Shaira Bano controversy, Zakia Soman and others have been writing, they had gone to the Supreme Court. Shaira Bano also said that polygamy should be banned, nikah halala should be banned. There is nothing like nikah halala term. This is a new term they have invented. Muslim jurisprudence does not know of nikah halala as a term. Supreme Court, of course, decided that they will not hear other matters except the triple divorce, and therefore you got that judgment from Supreme Court on 22nd of August, confining itself only just to the question of triple divorce and not the other questions raised in the PIL. My position on the issue has not been fully understood. And you rarely get an opportunity when you are writing a piece, you will write in 1500, they will say, no, make it 800. And therefore in 800 words you can't really express yourself fully, and therefore newspaper articles are not to be considered proper research papers. They are just op-eds to flag an issue or to start a debate, a public debate. I will make my position clear, but more than my position, I would make the law clear to you on the question of polygamy. I would first of all quote two very eminent American sociologists, G.H. Locke and J.A. Peterson. These are American sociologists, Locke and Peterson, and this is what they said. I quote, "Where polygamy lacked sanction, legal sanction, where polygamy lacked legal sanction, it frequently existed in the more or less illegal form of concubinage." American sociologist, where polygamy is not allowed, in spite of oppositions of morals. They are saying where polygamy lacked legal sanction, it frequently existed in the more or less illegal form of concubinage. I am not entirely in agreement with this statement, but the evidence available from India supports their argument. And what they are saying, I am just going to show to you, has been accepted by the Law Commission. What they are saying has also been said by the Supreme Court. When Hindu men indulge in polygamy, and polygamy is illegal as per the Hindu Marriage Act and as per the Indian Penal Code. The question which I have been asking, and the problem which I have with the proposition, banning polygamy, mind this word banning. As a criminal law teacher, I know banning means prohibited, making something a crime. Will banning polygamy reduce polygamy? This is a limited question. There is no value judgment here, whether you favor polygamy, you don't favor, I don't. But will you get the desired result through the instrumentality of criminal law? That is the question, when you make it a crime. The other statement which I want to make, and as a student of Nalsar, I want my students to reflect. We believe that public policy need not be constrained by a dominant, commonly held moral conclusion. Public policy debates, the questions of public policy, what should be the policy? Should we only accept whatever is the dominant moral statement? When I wrote this, privacy judgment was not there. Privacy judgment acknowledged this. The view of the majority in a country on any given thing is irrelevant for the issue of privacy. So majority of us may think that the sexual minorities should not indulge in same-sex relationships. Many of us believe it's a sin. But the law has to look at that individual. If it is a choice of an individual to be a gay or a lesbian, then we can't do much about it. The whole country may think otherwise. But if that one individual makes that choice is to be accepted. because it is part of his choice, his autonomy, individual autonomy. Similarly, the views of minuscule minorities, if that is their choice, is to be accepted, is to be acknowledged by a legal system. In a legal system, we are not going to impose our morality on everybody or our worldview on everybody. We may consider their view as abhorrent, as sinful, as immoral, yet we have to permit it. Public interest is different. You can't say it is a public interest to punish homosexuality. That is your view, that it is unnatural. For certain people, it may be natural. So public interest will not help you criminalizing homosexuality. And that is why Supreme Court has almost overruled its own decision of Justice Singhvi in the Nas Foundation case. And I am very hopeful that it is a matter of time when on merit this case is heard, the Supreme Court is going to agree with Delhi High Court rather than with its own judgment. Let me give you one more perspective. One perspective is, in a legal system, public policy need not be constrained by dominant, commonly held moral conclusion. This is one view, one point. I give more strength to this view by making a second statement. Public policy, to be effective, should be really pragmatic, more moderately developed, because over time people change their opinions. So what was our opinion on homosexuality 20 years ago is not our opinion today. Whatever was our opinion on gay relationship, same-sex unions 10 years ago is not our opinion today. And therefore there cannot be permanent judgments on matters of public policy. There was a time when we thought coalition governments are bad. We need a single party, massive majority government. Maybe tomorrow we change our opinion and we think federalism is better served in a coalition government where regional parties have a substantial stake in the center. Look at the kind of opposition you are seeing from TDP and Jagan's party to the central government. They are saying, even though we are a part of the coalition, we have not got a fair deal. If regional parties support is necessary for the survival of the central government, regional parties will not be taken for a ride. So we will change our opinion. We keep changing our opinion. Public policy issues are not static, settled forever. So be pragmatic. Don't be just an idealist. An idealist, what you think is ideal. Idealist, our opinion is the best. That is not how public policy decisions are made. Did not we in India look down at live-in relationship until recently? Yes? And now Supreme Court says a live-in relationship is perfect. It is choice of two people. There is no law which prohibits people to live in. We change our view on live-in relationship. We change our view on prohibition. We change our view on prohibition. Number of states brought it, implemented it, then rejected it. Why are we opposing Nitish Kumar's liquor ban in Bihar? Because we know liquor ban has not worked elsewhere. Even in the dry state of Gujarat, if you want, you will get it. Raees movie भी देख ली आपने आपने Therefore, prohibiting it, punishing people for drinking is a regressive step. So we keep changing our opinions. Polygamy, similarly, in my opinion, too involves an element of privacy. An element of choice. And therefore we need to consider, should you have an unlimited choice? Or will your choice be restricted, keeping in view of the choice of your spouse? Interesting fact situations come to our attention. A friend of mine, happily married couple, both loving each other like anything, not having the child, a Hindu couple. And both husband and wife very keen to have a biological child. Our suggestion to go for IVF did not interest them. And the wife was bent upon that you take a second wife. They will go to a lawyer. What will be the legal advice? You cannot take a second wife. If you take a second wife, it is an offense. Therefore, what is the remedy? The remedy is you divorce your loving wife, the caring wife. And the man does not want to divorce. So there will be hard cases. Law is tested in hard cases. Law is not tested in normal cases. Is there a way out? Should there be a way out? What will be a way out? These are the questions should be considered, rather than jumping to the conclusion this way or that way. TV debates don't allow that kind of discussions to take place because we keep shouting at each other. So reform is not only a relative term, but also one laden with a wealth of subjective overtones. There is no magic about monogamy, nor is everything bad with polygamy. I'll come to that. This is old argument. So what are the dangers in this whole debate? That is not paid much attention. So Hindu bigamous husbands go scot-free. They are not punished even though law punishes them. as judiciary can do little unless aggrieved wife lodges a criminal complaint. In the triple divorce bill, this is what Muslim women are asking. Just like polygamy, you restrict it to the wife. If she wants to file the complaint, then only she should file complaint, to which the government is not agreeing. The moment she files a complaint, what will happen? Her relationship will get further strengthened. He will come, hug her. Oh, very good. You filed an FIR against me. Let's go for a long walk, long drive. Let's have a outing outside. What will happen? The relationship gets destroyed. And therefore, I said pragmatic considerations in public policy are important. What you feel, that shouldn't become law. And therefore, what will happen? She will not file. Many women in India are not economically independent. And therefore, she will tolerate all this nonsense. And when she files, assuming she files the case, what is the burden which law puts on her? She has to prove that she is a legally wedded wife, and the second wife is also legally wedded wife. Then only there is bigamy. And unlike Muslim marriage, where there is a document called nikah nama, for Hindu marriages there is no document. And there are cases where the first wife who filed case against the husband for taking a second wife could not prove her own marriage. And if you are not able to prove your status as married wife, you go out and the second one is already in. Holmes has said, experience of law is not, life of law is not, it's, that experience is not talked about lately in India. And for a Hindu marriage, you have to prove that the second marriage is valid. What kind of judgments you have? Somebody married in the Tirupati temple, there is a picture available. Court said marriage not proved. Because the word, necessary word in the Hindu Marriage Act is solemnization of marriage. You have to prove solemnization of marriage. In a case in Gujarat, where the marriage was registered with the registrar of marriages, there was a court marriage. The court said it is not solemnization of marriage. And the first wife did not succeed. In number of second marriages, Hindu men, instead of taking 7 steps, Satpati 5 ही कर लेते हैं, 4 ही कर लेते हैं. Because in Northeast, even 5 steps are enough for a marriage. So proving solemnization of marriage of your own and then marriage of the second time is such a difficult task, such a difficult task. And many a times what men do, I told you men are men. So they will have some good time with the second wife, and then they will realize she is not much different from the first wife. After some time that enthusiasm goes. So they will return to the first wife. And the second wife is left high and dry. And when the second wife went to the Supreme Court asking for maintenance, what did Supreme Court say? You are a mistress, not entitled to any right. So the equalization we are aiming at, that a second Muslim wife should be in the as worse position as the second Hindu wife. Should that be a public policy? You should be improving the status of the second Hindu wife. Because under Islam, if there is a second Muslim wife, she is entitled to residence, just like the first wife. She is entitled to maintenance, just like the first wife. She is entitled to meher, just like the first wife. She is entitled to succession. In your property, if you die, she will inherit, just like the. And therefore the status of a second Muslim wife is very, very high if you compare the status of a second Hindu wife, whom the Supreme Court is on record. If you want the name of the case, I can give you the name of the case. Let me find out. D. Velusamy, Justice Kadju's judgment, saying that a second Hindu wife is a keep, is a mistress. This is how you treat women. You call her a mistress, a keep, just because your law has prohibited somewhere that you will not take more than one wife. That's ridiculous. So the Law Commission in 227th report, I made a mention of Law Commission, 227th report of 2009 lamented about the existing bigamy law under Hindu Marriage Act. And it said it is indeed full of serious shortcomings and law loopholes. I always say, a remedy which has not worked, why continue with that remedy? Reject that remedy. Find a new remedy. If one medicine has not worked, we should continue to give the patient same medicine. We should find new medicines. It went on record, Law Commission, and said many men whose personal law does not allow bigamy have been resorting to unhealthy and immoral practice of converting to Islam for contracting a second bigamous marriage. In Sarla Mudgal, Supreme Court of India made all kinds of comments about Muslim law, talks of Uniform Civil Code. The real blame, because in these cases, there were Hindu women who had gone to the court, whose husbands have taken a second wife. So who committed real crime? Muslim law or these Hindu husbands? Hindu husbands. And court made such wrong observations, creating this whole idea of the other, that we in India 1947 decided that there will be one law and everybody will be guided by that law, this and that. It's not the government which is to be blamed for creating this idea of the other. If you minutely look at Sarla Mudgal decision, some of the observations of the Supreme Court are highly problematic. That other is now becoming enemy and creating divisions in our society, which is not good for a nation which is going to lead the world or should lead the world. Therefore, what is the ground evidence? What is happening on the ground? 55, we prohibited bigamy for Hindus. What is the evidence on ground? Leading politicians, Karunanidhi, Mulayam Singh Yadav, BJP's own MP Hema Malini, Modi Sarkar's cabinet minister Ram Vilas Paswan are in bigamous marriage. हम पढ़ते नहीं है लॉ को ठीक से, वो तो एक सब्जेक्ट है, रटा रटाया इम्तिहान में वॉमिट कर दिया और पास हो गए. Look at law and legal issues more closely. To study polygamy, I had to study sociology. That's how I went to sociologist, American sociologist. Official reports, the most authentic work done in 1974, after 2 decades of 55 law. It highlighted the shocking fact that polygamy is prevalent amongst Adivasis. What is the rate? 15%. Hindus, 5.8%. Jains, 6.7%. Buddhists, 7.9%. Muslims, lowest of all, 5.6%. Even though it is permitted. And we are making so much of hue and cry. And this percentage does not give you the correct figure. I will give you the correct figure. Calculate it more closely, as a real student of law has to do it. According to 1971 census, because we are in 74, there were 45.3 crore Hindus. And there were 6 crore Muslims. Therefore, if this percentage is converted into numbers, what will be the figure? And then you have to see that approximately 65% of each community will consist of women and children. And we are not talking of polyandry. So we have to exclude women and children. So that 65% will also go. Then whatever is left, then you have to find out what is the percentage. And you will find, as opposed to 12 lakh Muslim men, 1 crore Hindu men were in bigamous relationship. And then the difference is this, 1:10 almost. 1:9. Therefore, when something is prohibited and banned by law, that does not mean it goes from the society. And that's why my opposition to excessive criminalization of anything. Because that really does not help. I'll finish this and then allow you to go. Because this is your last class before mid-sem. That was the old figures. Malika B. Mistri's 1993 research too showed no evidence that percentage of polygamous marriages among Muslims is higher than Hindus. According to Third National Family Health Survey of 2006, as many as 2% women reported that their husbands have more than one wife. And therefore I say, outlying polygamy has not worked. And therefore think of out-of-box solution. What can be those out-of-box solutions? Before we go to that, because that will apply to all communities, your out-of-box solution, if it becomes part of general criminal law, it will be applicable to. Let us look at the whole question of polygamy in Islam. I have said it before and I say it again, that in this entire debate on triple divorce and the issue that it is not there in Quran, as Justice Korean Joseph said it, or even Justice Rohinton Nariman, or number of petitioners. Therefore it is not there. I think we must always make a distinction between what I call Sharia and fiqh. Sharia deals with the relationship of man with God. Fiqh is human speculation about human problems. And therefore Quran is a source of law rather than a law in itself. It incorporates broad, higher principles. And Quran, along with other sources of Islamic law, from Quran and other sources of Islamic law, we have to infer law, we have to drive law. The God, in my opinion, has in his wisdom decided not to give us a ready-made law. Therefore, Quran is not an enacted law like a statute, Indian Contract Act, Indian Penal Code, Indian Constitution. Because that is the wisdom of God. You want law, make efforts, make endeavors, apply your mind, think over, look at your society, look at your times. And therefore you have to extract law. The beauty of Islamic law is it permits human enterprise in making of law, in extracting of law. And that is why in Islam, law is jurist given. Jurist indulges in that exercise of extraction, in that exercise of reading all the sources, thinking of public interest, thinking of analogical deductions, thinking of consensus, thinking of customs of people, thinking of opinions of other jurists, and then give us a law. So law is not a finished product given in Quran. You have to find your law. You have to extract your law. You have to drive your law. And therefore, if something is there in Quran, it does not become law unless the jurists do this juristic exercise. Similarly, if something is absent in Quran, that does not mean it is not permitted. Because jurist has to do a similar exercise both ways. So there is a verse in Quran which permits men to have more than one wife, but not more than 4. From an unlimited polygamy, bringing 4, restricting it to 4, was a step for gradual movement towards monogamy. Instead of having an abrupt abolition, which may not work, which may not be accepted, pragmatic lawmaking, public policy, so restrict it to 4. And then an impossible condition that you can take more than one if you can do justice amongst them, if you can do perfect equality amongst them. And that perfect equality is not possible, howsoever best you may try. And therefore the advice is from Quran, have one. And therefore even Quran prefers monogamy. It permits restricted polygamy in extreme situations. And doing equality itself is a very difficult task. If you have 2 apples and 2 wives, you can't give 1 apple each. You have to slice it into 2. Half, 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 because each apple tastes different. Tunisia's president, in undertaking law reforms, you know how the jurists will work. He said nobody can do that perfect equality, that perfect justice between wives, except Prophet who was divinely inspired, and therefore other than him nobody has a permission. And that's how in their law reform there is monogamy. It's a different story that in spite of such laws in some of the Muslim countries, still you have incidents of polygamy, as these 2 American sociologists has rightly said. But in most countries, and that is another problem with me, that the Modi government, in its affidavit in the triple divorce matter, and also in its debate in Lok Sabha on the triple divorce bill, has cited examples of Muslim countries. I have a huge problem with Muslim countries because I don't consider them as model legal systems. My training in Western law convinces me that the Western legal traditions for modern times, promoting and celebrating individual autonomy, are the models for India to adopt, rather than looking at regressive, dated Islamic countries' model of laws. And therefore, from the examples of the countries which they quoted, as many as 10, and why they included Sri Lanka in that list, I don't know, because Sri Lanka is not an Islamic country, it's a Buddhist country. In all these countries, of the examples they quoted, polygamy is permitted. You have to apply to the court. Court will see whether you have means. Court will see whether your first wife is agreeable to this proposition or not. Court will see whether you have made adequate provision in terms of residence, a separate residence, in terms of maintenance for that first wife. Then court will permit. Since we have quoted these countries, Can we accept this proposition? I don't think Indian public opinion or Indian intelligentsia is willing to accept even this restricted polygamy. And therefore, citing their example, misfire. Citing their example may not be the best thing to do. Another myth which goes on and on is that no law reforms in India have been taken in the Muslim law. This is not right. The 1939 Dissolution of Muslim Marriage Act was passed at the instance of Muslim clergy. And if you take a second wife, it is a cruelty to the first wife, entitling her to get divorced. I have also discussed in your class that most of the nikah namas of the Mughal period did include this condition that if you take a second wife, wife will divorce you. The marriage will be dissolved. I had asked personal law people to consider adoption of a progressive nikah nama where this condition should be there, that you will not take a second wife. You will not give a triple divorce. Because that will bring in much better and quicker reforms. The last point which I want to make, which is little controversial, is about all the communities taken together. And this is in the light of what is happening globally today. We are so obsessed with our Muslim population and we think they are so regressive, we don't look at the global evidence. Three leading experts of family law in the world, Duncan Derrett, Anderson, Werner Mensky, they have opposed outright ban on polygamy. And they have favored restricted polygamy. But this restricted polygamy is to be permitted to all communities. Even in United States, there is a call to legally recognize polygamy in some situations. According to one empirical research, the percentage of Americans who find polygamy to be morally acceptable has more than doubled since 2001. Acceptable, not against. The percentage of people who think it is morally acceptable. And due to this increasing acceptability of polygamy, Ross Douthat in New York Times has predicted that polygamy could be legalized in United States as soon as 2040. I have said somewhere, and I say it again, India prohibited polygamy not because it was our tradition to prohibit and to have monogamy. Hindus have not been monogamous traditionally. Even Raja Dashrath had 3 wives. Kaikeyi and Kaushalya and Sunita. We adopted it from the West. Monogamy was a European idea, American idea. And there is a rethinking going on in America itself. And that evidence we can't be ignoring today when we take our public policy decisions. Brad Wilcox of the US National Marriage Project attributes polygamy's increasing popularity to, what is the reason? Why it is becoming acceptable? Leading expert, Brad Wilcox, attributes polygamy's increasing popularity to an increasing libertarian or laissez-faire view that many younger Americans take towards sex, marriage, and family life. It has nothing to do with the state. Marriage is a private matter. Family is a private matter. Sex is a private matter. Therefore, you will not punish homosexuality. Huh? Yeah. Get my point? So this individual autonomy, in the name of individual autonomy, they consider state should go out of this. State should not bother about private lives of people. Generation next of India is not very different from United States. Indian youngsters also believe that no one should have any say in determining the contours or contents of a marriage. It is my relationship with somebody. It is your relationship with somebody. Nobody else. No third person, not the state, should have anything to do with it. There have been in United States raids if you indulge in a bigamous marriage, because in Utah, state of Utah, where majority of people follow this later day church, Mormons, they believe in second marriage. There have been night raids arresting people. What are called short creek type raids or Operation Seagull. There have been raids. People were arrested. Today's America is not willing for that kind of thing. Today's India is not willing for that kind of thing. And therefore, individual autonomy decides like this. Scholars like Andrew D. Davis are of the view that polygamous relationships also have the ability to strive for this ideal. What is this ideal? Ideal of equality of spouses. Equality of spouses. If we need to have equality of spouses, can we borrow from corporate law? What is whole corporate law business? People decide what kind of relationship they want. Shareholders, you form a company, memorandum of association, this and that. Limited liability companies or partnerships. Can marriage also become, that's why I said it is very, very controversial suggestion. Can marriage be considered as a corporate union? Can marriage, it is a contract already, where parties have equal bargaining power as opposed to status-based rules. In our current marriage law, there is a status of a wife, a status of a husband, as opposed to status. Henry Maine has written, societies move from status to contract. And they say Eastern societies are backward because they have not moved from status to contract. Our whole Hindu joint family system is status-based. Birth is a status. Caste system is a status. Co-partnership system is a status. And that is why we have not yet made the wife as a co-partner. Because she is coming into the family through a contract, not by birth. Can we think, therefore, that based on business models, regulated polygamy could be more in tune with the freedom of contract doctrine than the sacramental monogamy? Equal say is to be given to all the members, including wives, in the entry and exit of any member with rights and liabilities clearly laid down. You can write in the marriage contract. If you want to marry, this marriage is dissolved. Get lost. मैंने आपको बताया मुगल इंडिया में ऐसे कॉन्ट्रैक्ट्स थे. You can also write in the same contract that you will marry with my consent, but you have to first deposit 1 crore rupees with me. You have to give me a flat at Banjara Hills and maybe another flat at near Geneva Lake. Anything can be written. And therefore I believe there is more. One more thing which I have not written really, but I keep thinking. I once told Ravish Kumar, you have all kinds of insurances. India of today is talking of health insurance, of course, without allocating proper money for it. What about marriage insurance? If something goes wrong, can we think of it? All right, we'll continue. Huh? Okay, done. Until what I taught today.